Hello, everyone. Welcome. Thank you for joining our webinar, Psychology of M&A Deal Making Tips from Partners, presented in partnership between the Legal 500 and Krishnamurti & Co., otherwise known as KALO, the India-based full-service law firm. My name is Alan Cohen. I'm a research editor at the Legal 500, and before I hand over the webinar to our panel today, I'll give a brief introduction of the topic. In any large-scale M&A, a lawyer's role is to address the stakeholders' interests and close the deal in a timely manner. And this is why our panel has decided to discuss the factors affecting M&A deals, such as regulatory and market conditions, the key skills to manage a transaction efficiently, the practical aspects of assessing and mitigating risks, and also to provide several tips for negotiation, particularly on when to hold and when to fold. But first, let me introduce the panelists who will moderate and lead us through the discussion. Joining us is Mr. Atul Jouvlet, who is the General Counsel and Compliance Officer at Schindler India. Mr. Jouvlet appears in the top 100 GCs 2020 by Business World Legal and in Forbes India in the top GC list published in 2021. He's also an advisory board member of the ICFI Business School in Mumbai and the Advisory Council for ACFE USA 2022. Also joining us is Dr. Akil Prasad. Dr. Prasad is a member of the Board of Directors, Group General Counsel and Company Secretary of Boeing India. He's over 27 years of experience as a GC for renowned companies like the Fidelity International and Fidelity Investments, the Walt Disney Company, General Motors, Electrolux, Xerox, and the Modi Corp Group. He is a founder of the General Counsels Association of India, a visiting faculty at several prestigious institutions, and he has been nominated and recognized by prestigious general counsel list, including in Forbes India, Business World, LexisNexis, the Indian Corporate Counsel Association, and in our Legal 500. We also have Shwetambari Rao. Shweta is a senior partner at KALO, where she started her career in 2004. Ever since she joined the firm, she helped her practice grow, and now, in fact, she heads KALO's corporate and commercial practice in Bangalore. As a specialist in her practice areas, she has advised on several high-value transactions involving the structuring and setting up of business operations in India. She specializes in M&A, joint ventures, private equity and venture capital, inbound and outbound investments, project finance, commercial contracts, e-commerce, and corporate restructuring transactions. In addition to that, she's a member of various corporate boards and special committees in relation to law and governance, but also, and I know this is dear to her heart, Shweta is a member of the advisory board of Balutsav, an NGO dedicated to the education of the underprivileged in India, and she volunteers at Snehalya Children's Homes, where she mentors children. Our fourth panelist today is Rukmini Chaudhuri. Rukmini is a partner in KALO's corporate practice group and represents leading companies and reputed individuals on varied domestic and cross-border corporate legal transactions, including M&A, PVC investment, and structure finance deals across diverse sectors, really. She also has significant expertise in debt restructuring and settlement and special situation funding transactions. In addition, Rukmini is a trusted advisor to several technology companies on their day-to-day legal affairs and commercial contracts. She also acts as external GC for Baldo Technology Private Limited and a global top 100 RegTech company. Her articles are published in renowned publications, including Mondag, IFLR, and Asian Legal Business. She's listed in the Maiden Forbes India Legal Power List 2020 as one of the top 100 individual lawyers in India, and has also been recognized as a Rising Star 2021 by Asian Legal Business. In addition, she's also been featured in the Asia Law Profiles India 2021, and she appears in the Legal 500 Asia Pacific 2022. So I'll hand over to our panelists in a moment, but before that, I would like to let our audience know that these session is interactive. So if you have any questions at any point during the webinar, please submit them using the Q&A session function, at the bottom of your screen. And so we'll put them to the panel once the presentation is over. Okay, then, Shweta, I'm handing this over to you now. Feel free to introduce your topic further and lead the conversation, get us on the way.
Thank you, Alan. Thank you so much for the introduction to the topic as well as to each one of us. And I have to thank all of you for being here today. It's a post-lunch. We'll try to keep it interesting. We'll make sure that you all don't doze off. And thank you, Atul. Thank you, Akil, for being here. We here are, Rukmini and I are more commercial lawyers. We are partners at a law firm. But having you here, we're delighted, we are honored because you both of you are the business stakeholders, right? So your mindset, your sensibilities will definitely add a tremendous value to this entire discussion. Thank you for being here. So moving on to the topic, a psychology of M&A deal making, right? Very interesting topic, very dynamic. I think all of us have on this panel have done enough and more deals, but each deal that we've done is unique and very different to the other. I mean, M&A deals are done because of the purpose of it being strategic alliances, economic growth, moving to new jurisdictions, consolidation. But what is the one common goal by the end of it? It's making sure both the parties take this discussion or negotiations to deal closure, right? So keeping that in mind, I think, and the reason we've also chosen this topic is, I think everyone knows 2021 has seen an all-time high when it comes to M&A activity. And then I think also the announcement of HDFC Limited and HDFC Bank, that is one of the biggest financial mergers that we will see in India. So that these are exciting times. It should be, they've announced it now. They think it's going to be another 18 months for everything to come through. But yes, these are exciting times. So let's start with Atul. Akil, you all have anything that you all want to say from an object perspective for M&A deals?
Atul, you want to go first?
Yeah, okay. So thank you, Legal 500, Alan, for the best introduction and opportunity. I like this subject, that particularly psychology, because many things are prepared. There are documents, process, everything is there, but still what goes in the success of the M&A deal is a psychology. How do you handle the people? How do you handle the total steps, and how do you deal with the people? So it's interesting to discuss what are our experiences, and very important, particularly for the consultants, deal goes well, it's okay, not goes well, okay. But for legal counsel, it's a losing of job if deal doesn't go well. So would like to share certain definitely experiences going forward. Over to you, Akil.
No, I agree with Atul, and in terms of the philosophy, what I would like to add is that, it depends upon an organization to organization as to what are those broad objectives of going into an M&A. For example, the one you said, Shwetambari, about HDFC, how I see it, I think it's a merger of a parent with a subsidiary, wherein, they want, the chairman of HDFC did make a comment that, the son has outgrown the father. So it's about integration of, son with the father or father with son. So that is one philosophy. But then there are several other philosophies, you want to kill competition or you want to grow larger. So that could be a horizontal or a vertical combination that companies look for, especially, when we are looking at startups, who want to grow really fast. For example, we have seen Byju's, and we have seen, companies who were not there 5 years or 6 years ago, but the philosophy is to make a mark quickly. And, they are fortunately backed up with a lot of green dollars, in their companies so that, they can make that presence felt immediately. We have also seen instances like Paytm, which till not very long ago has been a blue-eyed boy for, the growth story of India, but suddenly things change. We have already seen instances like Nika, a fashion retail business, getting a valuation which is completely unheard of. So I think all these kind of transactions are very, very different. What is common, at least for us as lawyers, is whether it's a merger or a demerger. From a legal compliance and a documentation point of view, I think the structuring is not very diverse. There may be some differences here and there on the business nuances, but on the contracting side or on the regulatory side, it may be similar. So these are the opening comments, Shatanti.
Thank you, Akil. Thank you, Atul. So moving on, I think because this topic is so dynamic, what we've thought is we'll make it a little, the flow of the discussions a little more structured. So we'll start with the term sheet. I mean, I know there's a lot of groundwork that goes into the whole discussion before the term sheet is even rolled out. But thankfully, most of the time, the lawyers, at least we as partners of a law firm, are not involved. I'm sure it's different for you, Atul, and different for you, Akil. But yes, whether between the iBankers and the business stakeholders, you all take care of that bit. And then it comes to the term sheet. So I think the first topic over here is whether a term sheet is even required, right? Because it's non-binding. And business terms are discussed, it's captured on email. And legal terms, we anyways have the definitive agreement. So what do you think, Rukmini? Do you think a term sheet is even required in the first place?
Thanks, Shweta. So now this would depend on, why a term sheet, right? For a listed entity, the approach will probably be, let's not have a term sheet because there are disclosures, etc., involved. However, for an unlisted entity, for example, the term sheet actually helps in securing exclusivity on paper at least, and also providing a framework for parties to actually, I think this is where the psychology really comes in at the early stage, where you see how the buyer and seller are engaging even during term sheet discussions, right? If there are any major showstoppers, for example, often the manner in which a term sheet is negotiated can weed out that showstopper. And before the buyer expends or the seller expends any further resources, if the deal needs to die, it dies then without, a huge expense and resources. On the other side, what it also does is in any M&A deal, it's not just the buyer and seller. There are many, many other stakeholders involved, from business, from financial advisors, ESG auditors. There are various stakeholders involved. The term sheet sort of gives everyone a sort of framework as to how they want to take the deal forward. Now, in terms of how, to this question, I think I'm going into your next question, which I suspect you're going to ask, how detailed should it be? So in terms of detail, now, the approach that we are seeing is changing quite rapidly as buyers and sellers deals become more sophisticated. No longer is it this really lengthy, granular document. It is actually something that sets out clearly the commercial objectives, any, really non-negotiable conditions on either side, but the rest of the minutiae is left for the definitive documents.
So thank you so much. Atul, Akil, I would like to understand your views on this. Detailed term sheet, first of all, required, not required, detailed or short form? What do you prefer? What have you seen? And from before to what is it now?
So Atul, you may go first.
Privilege. Thank you. So I can say that for the client, it should be detailed. But when we exchange it with the particularly buyer, particularly target, we should be short, so that we have the detailing also at the back end. And term sheet is required even if it is a listed company. The reason is that at least we are formally setting down what we are going to do. So tomorrow, the next, particularly, we have to avoid the deal breakers, and that is possible if there is a documentation. So term sheets are required, and then, as I said, with the buyer targets, buyer or seller, whatever, it should be short so that the context is clear. Contents we can discuss.
Atul, I totally agree with you. I mean, it's such a good point. With the other side, when you're sharing the term sheet, brief, precise terms captured, and both parties know what they want to get into. But for us back end, to ensure that we know where this is going, to have a more detailed heads of terms or a long a term sheet, definitely. I mean, it's a new perspective. Thank you so much. I mean, this is what I tell my lawyers. Forget what the clients want, right? I mean, if they want to sign a short form term sheet, that is fine. They don't want a term sheet because we've had that situation going straight into the definitive agreements. But I've said for us, to whether it is to guide the client or to ask them questions on specific things, have a detailed term sheet for us as reference. Very good point, Atul. Thank you so much. Akil?
Okay. So while, as lawyers, we may want to, we are trained to have signed the template documents. So, whenever you talk about a transaction, the first thing which comes to your mind is a term sheet. But things are evolving, things are changing very, very fast. And I think today we are looking at not lawyers, but also your business people driving a transaction. If I were to look at it from a business point of view, I think business preference is that a term sheet or a memorandum document should be as simple as possible so that parties very clearly understand, what is it that they want to translate as a business objective. And then it is left to the lawyers that when you get to the definitive agreement stage, you chalk out the granularities or details about a M&A transaction. But one thing which troubles me is, and that is why I insist on a term sheet, is the confidentiality part. And because confidentiality is so important, because we tend to enter into a transaction, we tend to disclose our proprietary information. We receive proprietary information of the counterparty. And that is where, I try and educate our business people that if you were to have a term sheet, and if that term sheet is supplemented either by a confidentiality agreement or has confidentiality clauses, it definitely helps and protects your business information, which may be a proprietary information also. And that is a logic I normally try and use when people tell me, let's do it over an email, let's make it very simple. So all those things are good. But tomorrow, if somebody comes back to you and tells you that, oh, well, I went into that meeting, I shared my drawings, designs, and, blah, blah, blah. This deal did not happen. How do I now protect, whatever I have shared? And that is the problem, which as lawyers, we'll be in a very difficult situation. If we give that leverage to our business people, that, the term sheet never had any protection clauses on the confidentiality, or it was not supplemented by way of a confidentiality agreement. That is why perhaps, I will agree it should be simple. The business objectives perhaps could be a part of the annexure. It could be a 1-pager or a 2-pager. But whatever goes into that discussion, whosoever carries that information into a business discussion, perhaps we need to protect that, for which it may be essential to have a term sheet or a confidential agreement or a combination or a hybrid.
Correct. Thank you, Akil. And I think on that point, it's not only for confidentiality, correct? I mean, as a buyer, you'd want that no shop clause or the exclusivity clause also built into the term sheet, which is binding. And have you seen over the years how the exclusivity clause has become critical or pertinent, or when the period has expired, what has transpired post the lapse of the exclusivity period? Have you?
Yeah. See, fortunately, we are on the OEM side. So, I don't want to say at this forum that, it's, we have one-sided agreements. That's not the case. But certainly, for companies like who are, customer facing, who are making products and services which are out in the market, they definitely have an edge over their suppliers, because ultimately suppliers are dependent on you as a OEM or a go-to-market service or a product offering. And then you have that, I'm not using the word muscle, but you have an advantage that you tend to make your suppliers agree that they are going to offer you these rates exclusively or services exclusively, competition law allowing it, those kind of things, antitrust or competition law allowing it. If you were to make that kind of an agreement, I think that is something which will always be the preference.
Got it. Thank you, Akil. Atul, anything from you here or Rush?
No, actually,
Yes.
I just no, I don't want to be long. I just wanted to particularly we discuss on this particularly competition part of it. The reason is that today the major particularly important point to comply is the anti-competition, or maybe our objective should not be entered. There, I think we should. I think I request your explanations particularly. How do we deal with? Because you mentioned that, and Akil mentioned about the objectives. And objective should not be anti-competitive. So I think we should be careful about the drafting of that.
Correct. Atul, this is for me or Akhil?
No, we want to hear from you because now it's on the webinar, so it will be free.
I think correct. So what I was talking about from an exclusivity perspective, I understood what Akhil was talking about. It was more an exclusivity when the deal is done and it is about not getting into arrangements with their competitors and things like that. But I was talking from in the term sheet when we say exclusivity or no shop clause, right? It's about ensuring that you're not discussing that sorry.
No. Actually, I'm not talking of exclusivity. I'm talking about referring about the objectives of the transaction.
Correct.
There we should not have the objectives which will be anti-competitive.
Correct. I mean, and that we have the CCI with the relevant thresholds, and we even have provisions, even in the standstill provisions, right? Anything that if you're saying that during the standstill provisions, while we are getting the CCI approval, 1, 2, 3 things cannot be done, it still becomes not within the ambit of the law. So yes, I think the whole object is to make sure that there's, sorry?
Yeah, there is one more dimension. For example,
Correct.
There are also regulatory reasons. For example, if you were to look at a media industry, we have Hotstars, we have Sony Lives, we have so many, apps these days. And the recent example, we saw the release of the movie 83, which was, many media company wanted to broadcast it. Then we have seen issues like telecast of cricket, whether it's IPL, who gets what. And then, the TRAI regulations, they talk about must carry, must provide, and they say that you cannot have an exclusivity for a particular content. That content should be freely accessible, which is of national importance. So in addition, so what Atul mentioned, I think in addition to competition law, I think the other dimension also is a regulatory aspect, that if we are trying to create an exclusivity, whether the regulation or the regulators of that particular industry allow exclusivity or not. For example, we may have so many restrictions under the telecom regulations when you are transmitting content or data. So that has also becomes a very important part when somebody tells you, I want this exclusive deal. So I think the lawyer's mind should start churning whether or not the regulations allow, the regulators allow, or the competition law allows. So it's a very difficult subject on exclusivity.
So shall I move on to, I think what I want to understand, Atul, from you is what do you think? I mean, we've moved on from the stage of a term sheet. We all, I think the conclusion is that yes, a term sheet is required, shorter the better, more precise the better, right? But what do you think is the most difficult stage or something that is challenging during this whole deal making process, Atul?
So actually, the every stage in the deal is challenging, and there are surprises which we have to handle. But most challenging from the general counsel point of view, or maybe company point of view, is the due diligence. Because in the due diligence, what happens is we have got short time. Always time is because the business people who want to close the deal, they are always on your head. Whereas our task is to find out the dark spots which are not there in the documents, and maybe which may be the beyond documents. So that's actually a tough situation for general counsel, I will say, and maybe for the people who are dealing with also, even for the law firm also. I have seen spending overnights with the lawyers partners, particularly law firm partners, on this due diligence. And the another part is that even after finding that the business people doesn't want only problem, want solution also. So again, they will take our confirmation on objectively putting whether what is the financial risk. And every time it is not possible to indicate the financial risk. And I also seen one or two deals also that we could find the surprises after the due diligence. So that's also common thing. So according to me, challenging for the general counsel as well as the lawyers is the due diligence, because there our major role is to find the risk. Thereafter, it's a part of negotiation, and business people can handle.
Correct. Thank you, Atul. And I think during the due diligence process, I mean, due diligence will comprise of financial, technical, legal, business, yes. But from a legal perspective, I mean, when they are uploading from the seller side as well as the buyer side, right? I mean, we understand so much about where this is going and how the relationship will be during this process also, right? How the documents are provided to the buyer counsel for the diligence exercise, whether whether it's expedient, whether it's organized, right? These are few indicators. I think, Rukmini, you've had instances where everything has been organized, up to date, but then you saw a few challenges there also. Do you want to highlight some of this and the challenges that you faced?
I think before we come straight into that, one thing to note is that it depends on what kind of, our diligence has to be tailored to what kind of deal it is. For example, there are certain constraints. If it's a bid situation, or, you know, if it's a M&A through a CIRP process, for example, then what is uploaded is uploaded. I mean, it's pretty much on, you can't, it's very difficult because there are multiple bidders, right? You have to finish your diligence in a particular time. So there are constraints there. You know, where we have the luxury of time, for example, and we've seen that often everything is disclosed, you know, in a timely fashion, and many, whenever we ask for something, we've received the information. Yet, you know, there's just something innocuous. For example, oh, our fire NOC, we just have a provisional one, for example, right? And then we say, right, but you know, we can get it. This is not such a big thing. We can get it, right? And then we dig deeper, and we find out that actually the fire NOC, the final fire NOC, has not been granted because there is a defect in the construction itself. You know, the way the factory was constructed didn't have a passage. You know, it wasn't in compliance with fire safety regulations, right? So often we've had surprises like that. So it's not always what meets the eye, and it is for the lawyer to actually, you know, a lot of it is compliance based, and a lot of it is your instinct as a lawyer at that point, and your understanding of the seller, that comes into play.
Thank you, Rukmini. Akhil, any perspective from you? Because see, this I think we spoke about the seller side and how whether they're organized, whether they're not, and it's about once the diligence exercise is completed, the findings and how it is perceived by the buyer. Correct? Whether it is something, one whole list of CPs will be drawn out, or is this something that they can work with the seller and get sorted out? Any light that you have to throw on that?
Yeah, yeah. So I think what is very, very important is whenever you are thinking about an acquisition, I think the greatest thing is to think about what team you should constitute to do the due diligence. So as lawyers, for example, if we were to acquire a company which has a manufacturing facility, so lawyers can do as much. Lawyers can perhaps look at the title due diligence about the factory, whether it was under a particular industrial area, whether, it has all the legal documents, blah, blah, blah. But I think what is very, very critical is about the resiliency and sustainability of the project that you are acquiring, for which lawyers may not have the full knowledge. So although the expectation from lawyers is that you guys are working on a transaction, make it foolproof. So these are the kind of words we are told: make it foolproof, have a foolproof document, and then you end up in a transaction like a Fortune and an Amazon and Reliance Group, after lawyers having spent years over it and doing transactional work. But then this is what happens. But I think the point here is you can do as much as lawyers on a transaction, but you need to have the right team to look at every aspect of a business that you are acquiring, and which may not be a legal diligence. It has to be a lot of technical business, assessment and the work which goes behind it. So I think what gives me jitters is, when somebody just rushes into a transaction, and then you ask for, what are the business things, what is the checklist, that you guys have thought about. The business will typically tell you, oh, well, we have done everything, we have reviewed the business and all that, financial modeling, etc. But I think it's the part of a general counsel or an external counsel to at least ask what has been done, what agencies have been involved in doing a complete due diligence of our target, and whether or not it has been evaluated not only from a legal point of view, because that is what you are doing as lawyers yourself, but what are those reports which have been received, who has read those reports, who has signed off on those business aspects about the target which you are wanting to acquire. I think that is the most difficult yet the most important part.
Totally agree, Akhil. And I think especially, I'm not speaking for anyone else, but not many, of the transactions that I've been involved in, they've not stalled because of the legal findings in a legal diligence. Do you agree? Have you all seen? I'm sure there have been few instances for everyone, whether it's land related, like Rukmini said, imperfect title to shares. These are things that you cannot deviate from.
Somebody would buy a coal mine. Somebody would buy a coal mine and then discover there is no coal at all. So are the lawyers to be blamed for that? You are buying crap. You did not do due diligence. Who's to be blamed? Not the lawyers, for sure.
Correct.
I would like to just give one tip on this, particularly getting organized and unorganized data for the due diligence. These are red flag and green flag. Green flag, too much green flag also bad. If you are getting a complete file just to say yes, then also we have to check more, because then something which is not there in the file we have to find. So due diligence is really a tough exercise for not only consultants, lawyers, including the general counsel. And yes, you are right that your statement is right that for the legal risk finding, deals are not hard, because they are converted into financial terms and finally the particularly call is taken. But the deals are broken for many other reasons, like egos and all. We will have to discuss that when we negotiate.
Yes, that's a
So-
big topic in itself, Atul.
Yeah. Yes. So yeah, I think over to you again.
I
Thank
think,
you,
Shweta,
Atul.
if I can come in here,
Of course,
you know,
please.
that's an interesting point. So what we try to do in our practice is, and this also helps us suss out, the seller's thought process when we're acting for the buyer. As we go along and we see compliance items, etc., that can be easily rectified, we share that with the buyer to communicate to the seller, and we see how willing he is to rectify that. So, that's one of the, I think, if I were to say tip, we could say, well, the diligence isn't complete, but so far we found these things that can be easily rectified. Would you do it? Now, in terms of the large, high value items, obviously the seller is not going to expend any money, before he has sight of funds from the buyer. Like, he's not going to do something. He may not be ready to do something, that involves a huge investment. And that is understandable because he doesn't know whether the deal is going to go through, right? But the smaller things, if he's willing to start that process at least, that I think gives the buyer a lot more comfort.
Yes. Thank you, Rukmini. I mean, this is something that I would have brought up for the conditions precedent for under the definitive agreements. But thank you. I totally understand and agree with what you're saying. Sending information to them, action items, as and when we find it, will obviously help with reducing the lead time to closing. So yeah, thank you, Rukmini. And I think moving on now to the definitive agreements, right? Now, depending on the structure or the kind of deal it is, whether it's an asset purchase, whether it is a slump sale, deferred consideration, one-time buyout, the definitive agreements vary. But I think many of the standard legal points which are highly negotiated, indemnity, reps and warranties, I think getting into that and giving everyone tips on each of these points will just take us forever. So what we will do is, if you all agree with this approach, we'll take a few topics and talk about the nuances or something that is out of the ordinary that we've seen during our negotiations. Is that fine? Is that okay?
Yes, please.
Yes. Okay. I think one of the first points that I had, Rukmini, whether it's the payout to employees, right, in an acquisition deal, and how it is structured and what the buyer is okay with, and how the founder actually tries to sort that point or action point before closing. You have any thoughts on that, please?
Yes. So I think the issue here is twofold. It depends also, what the financial wherewithal of the seller is. From the buyer's perspective, I want 100% of the, if I want to acquire the entire entity, I want to have 100% of the company upfront. If there are any outstanding options, etc., as a buyer, I would want them, to be cancelled or paid out, or, the vesting can be accelerated or whatever. There are various ways to do that. Now, the seller may not have the funds to do it. There may not be enough internal accruals in the company to do that exercise. So from that perspective, how do we structure these things? I think it would depend on how comfortable the buyer is with the seller, how well they know each other, whether they're willing to, take the risk of maybe, funding it in some other way before the acquisition or simultaneously. But again, there's the risk that if the acquisition falls through for whatever reason, what do we do? So, these things are customized often based on, the relationships really. And we see these issues more often in smaller companies where, the founders, this is the first M&A activity they've been part of. They've just, they're trying to integrate into, it is their first business, etc. So what we've done is, we've said, at least in certain deals, settle the ex-employees out of your internal accruals, because we don't want disputes, etc., coming in. Get us, letters saying, I'm going to, from the existing employee saying that, I agree to the cancellation or relinquishment of my my options on the basis that I will get paid out within X days of closing. And then we've adopted that structure. So that's one of the ways of doing it.
Thank you, Rukmini. Before I go into the other standard legal clauses, I think, Atul, you did bring up this point about egos, right? Playing a huge part during negotiations, right? Before I leave the floor to you on giving me a few sentences on that, I also wanted to say that what we see as lawyers in India, because the market is like this, it's all based on relationships. I mean, we may highlight certain nuances, certain complications, I think, in a certain deal, and our client will just brush us off and say, listen, I trust that fellow. I will do business with him. I'm totally fine taking this forward. I mean, we've seen that so many times. I respect the client to take that business call and say yes. But sometimes it worries me because some of the legal nuances or the non-compliances are quite grave. So, but, and they're like, no, I trust the person. Let's go ahead with this. Anything that you want to say on that, Atul?
Yeah, relations actually or trusting the person depends on the discussion which starts once we have the first meeting. And the comfort also depends on the background of the person. Further, yes, as a lawyer, we highlight 20 or 50 points, but we also know that the probability chances of that risk is considered in the finance. So they take care that they said, I don't want to consider that as the risk. Probability is very important because even if the risk is highlighted, for example, Rukmini was talking about the payout on payout of the certain employee expenses or employee details, that can be waited till the transaction happens. That's one aspect. Or second aspect, the problem is, yes, you are right to in suggesting that at least X employees should be settled, because once they know who is buyer, their demand becomes double or maybe more also. Or sometimes the people who are not claiming, they would love to claim once they know that the company is targeted by the good company. So that also is there. So my view, when the calls are taken, it is our duty. Even as a general counsel, I believe in that, and I have done that many times, going to MD straight away and telling that yes, you are the final authority to take the decision. But I feel this point we cannot overlook. So that is what I feel as my duty. Not 20 points, but this one point, if you are overlooking, then it's a risky thing. So that's what I will say.
Correct, Atul. Thank you. That is firstly about if there are certain things that the business takes a call on and then they adjust the valuation accordingly. That is one. And we as legal folks, knowing what the nuances would be, highlighting it over and over again, and then saying, yes, can be the risk mitigation. Maybe there's no risk mitigation, but highlighting it to them is definitely very important. Thank you, Atul. I think moving on to, Rukmini, you've already brought up the topic on conditions precedent, right? Depending on what the structure of the transaction is, right? If it's a one-time payout and conditions precedent, conditions subsequent, really there's not that much you can demarcate there, because you want to make sure you're taking over a clean company, right? But we've also seen in when it is a tranched buyout, where we give that leeway to the founders to sort out some of the non-compliances. I think, again, it is the mindset of the stakeholders. When do you want to take this to closing? How much are you okay deferring some of these points to conditions subsequent? We've seen that. It all comes down to a case-to-case mindset, sensibility, comfort level with each other, right? So is there anything that, Akil, that you would want to chip in here for this point on conditions precedent, and whether you've seen anything that is nuanced?
No, I think it all relates to my earlier point that I was making. one thing which I would also like to highlight is that it is very critical for any M&A transaction to have a program manager, or a PMO office, because it is very critical for that person that he or she works together with the entire deal team to, get insights on the, what I call a decision tree matrix. And that decision tree matrix will have various components which all relate to both, condition precedent or post closing. And each and every condition precedent or a post closing should have a complete visible map checklist of each and every important aspect of the transaction. And it has to, the PMO's job is, to hold continuous meetings internally of the acquirer at times with the target, so that the timelines are met, the information flow is there, and only when you facilitate a particular order, which is very, very focused, everything is crystal clear, on an Excel sheet, is then you get that confidence of whether the condition precedents or the post closing timelines will be able to be met or not met. And then what we call today is also a risk chart, the risk heat chart, which is generated, which talks about that, okay, the legal compliance, the legal section perhaps is all green because the lawyers have done a good job, diligence is proper, but the red or the amber is somewhere where, we do not have enough information on the manufacturing capability or the business assessment, which should also, so we need to decide which area we are talking about should have greater focus through that PM office, program manager's office, so that, it's not that one person is driving it, but it's a collaborative effort of various functions within the organization. And then you are able to achieve successfully a condition precedent. So condition precedent to me will only happen if you are able to very thoroughly think about a process, a structure, implement that structure with all the important contours of a transaction, business or legal, and then, it is managed effectively. Only then you will have a complete grip and the risk of a transaction can be minimized. That is how I see it.
I completely agree with you, Akhil. I think, on conditions precedent, I think this is where, it is also a mindset issue. Now, what is the seller looking at? The seller is looking at, he doesn't want the conditions to be vague or broad. He doesn't want to give the buyer, the chance to walk away for something that is, after having come this far, which is why we see, sellers, parties are talking about break fees these days, which were not a very common occurrence, maybe, even three or 4 years ago. So from a buyer's perspective, again, it is, the acquisition is for value optimization in a relatively risk-free manner, right? So for him, there are certain conditions that are non-negotiable, like regulatory conditions. Things like if there are lender consents required, specific diligence findings, which, he is not willing to bear the risk of. And suppose he's acquiring the business because there are certain critical contracts, critical customer contracts that he wants. He would ensure that and those contracts have a change of control clause, for example. He would want to ensure that the seller, gets those in, because otherwise that directly hits at the value of the deal. So for him, this would be crucial. From a seller's perspective, if the buyer is insisting on the MAE clause, for example, this MAE discussion, Shweta, and it would be great if you could share your perspective on it. Very recently, what we have noticed on this is that, the seller is now trying to exclude things that affect, for example, COVID, right? They're trying to exclude things that affect the whole industry. So they're saying if, there's been a strike or lockout across the industry, you can't call that an MAE. But, Shweta has actually faced this recently in many deals. So perhaps you could.
No, actually not many deals, Rukmini. This was right at the beginning of the whole pandemic. I think no one knew where it's headed, what is going to happen. And this is a healthcare deal that we were doing. And we made sure we were representing the founders, but we made sure that we put in an exception under the definition of MAE, that anything related to any impact, any adverse effect due to the pandemic would not be construed as an MAE, because the buyer obviously knew what he was getting into. We were in the thick of the pandemic, and he still chose to continue with the negotiations with us, right? We went to the definitive agreement. For it to go to closing, we didn't want them to use this as an excuse to walk away. So we made sure we put that in. So yes, thank you, Rukmini. And I think
I would like to make one comment.
Yes, please.
Pandemic taught every common man force majeure clause.
Yes, definitely. Definitely.
That is true.
No, sorry, let me tell you, Atul, I disagree with you there. I don't think it only taught the lawyers. Every tenant brought it up.
No, I'm telling every man, every common man knows.
Common man. Okay, sorry.
Better than.
Of course. Sorry. Yes. I think every tenant, every landlord, I mean, more so I'm talking about a day-to-day perspective, right? I mean, we've looked at it from commercial arrangements, but every common man, like you said, went back to their lease deeds, looked at this and said, what do we do with this now? Atul, sorry, you were saying something?
No, I'm just looking at the time. I think we should talk about one good thing, maybe last point, which we can talk on the webinars. So suggestions. One good point, because there are 8 or 9 minutes. So
fair enough.
Yeah.
So negotiation styles, right? What shouldn't I mean? We'd love to hear from you, because as external counsel and general counsel, how, because our negotiation style would be catered towards protecting your interest to the best possible manner. However, you have also your internal risk matrix, and when to give. So how do we work together to ensure that we have the best outcome?
Thank you.
Akil, I will request you to.
Yeah, so the matrix that I was talking about, I think external counsel has to be a part of that matrix only. What we call as a PM, program manager's checklist. Unless an external counsel is completely glued on to the entire thing which is happening, I don't think we will do justice to the partnership that goes between a general counsel and an external firm. So whosoever is working on a transaction, whether it's a accounting firm, whether it's a tax firm, whether it's a internal finance, tax department, business, sales people, general counsel office, external counsel, everybody has to be on that list. And everybody, what I believe is, must see the entire picture. And that is what I call as a good part of a transaction. A transaction will only be successful unless everybody looks at the same big picture and they have access to information, which is very, very critical. For example, although people may hate it, but I love to read business reports, because that is something which I may not fully understand. I must be very candid here, but at least I have to first understand the transaction as a general counsel of the company. And only if I'm able to understand it, I will be able to do justice, because it should not be our objective, either as a general counsel or as the external counsel, only to work on a legal document. I think it goes much beyond that. And that is, I think, a good part, that the moment we are involved as a team and we have access to information which is not only legal, but business information also. And if it is not being done, we should ask for it. That, this is something I would like to see. I would like my legal team, whether it's internal or external, to have a view or to have a read on that, because, risk or issues may come from any corner. Somebody who will read it will definitely try to understand it. And if you understand it, you will highlight a risk. And that is what I see. A probable good part of a transaction is to have a complete overview for everybody who's working on that transaction.
Thank you, Akil. I think what we also need to understand here is when we're negotiating deals, right? We What is the objective? We've spoken about that. What each party wants out of this. Yes, we have to move this to closure, right? But it's also about, I think, during negotiations, what we've seen a few times. I mean, I'm not saying that many deals we've seen this, but we've seen councils saying, especially when we are representing the founders, target company, and when we the buyer council, saying this is standard, this is the fund mandate, this is the company mandate. I cannot accept that. I mean, that I feel sometimes it's lazy negotiations. That I mean, what do I go back and tell my client? This is standards, you can't accept it. And what we're also seeing, I think I'm sure y'all have seen that too. There's been a dynamic shift in the way negotiations are panning out, right? There was a time it was totally the buyer's market. Over here, there's so much that the founders, the sellers can actually ask for. I mean, recently we've had a founder saying fundamental warranties to be limited, right? Title of shares included in that. Fraud to be limited, because I don't want anything. I don't want to take a risk. I don't have anything hanging over my head post this. So I want everything limited. I mean, this is a dynamic shift from what we've seen in the past, don't you? Have you seen that too? These kind of asks, some of them reasonable, some of them not. Some
Yes. So,
Akil.
yes, you are right. They want to restrict that, but for that, the base is a due diligence. So that's why I come back again to a most difficult part is a due diligence. Due diligence has to be religious to find that. And I can tell you one example. We had a good due diligence, and last minute we found that one tax demand which was 20-year-old was on the stay order with the rate. And when we were looking at this particular 10 years back litigations from the research side, we got that. And it was not there in the particularly annual reports also. Fortunately, last 3 years annual reports have changed and they have to do everything, including the auditor's report includes all the pending tax litigations. So that's a good part in the change in the current side. But yes, you are right. They want to restrict. But when somebody wants to restrict, we have to ask. My one point is that once we are starting the negotiation, both the teams should work towards one goal, that deal is happening. And for that, if there are exceptions, they should go to their particularly bosses that this is the problem, and they should not become. My point is that closing of deal should not be closing of relationship, because you need relationship later also. So we have to maintain that during the negotiation as well as the deal. So yes, restricting indemnities raises the eyebrows, because then doubt comes that why do you want to restrict the indemnity? Because suppose if I am a clean person, why I should worry about any kind of indemnity, so long as it is related to the business.
Correct, Atul. I mean, I agree with you, but I've also seen that the change in the trend. Something like this was unheard of, because if you wanted the deal to go through, but these kind of asks are coming through from sellers. So that's what I wanted to highlight. And I think we literally have 2 minutes left. There's also a question from one of the people from the audience. This is Mihir Jain. To what extent sellers are comfortable putting in break fee clause in the definitive agreement, especially during the times of COVID? Rukmini, you want to take that?
They're not. But what I was trying to highlight is that, the trend towards how newer concepts which were not heard of before are now coming in. And, similar to this indemnity changing again, because sellers are also becoming sophisticated, even on to the last point. For example, why should a seller resist indemnity, right? Now, a seller would do that because they, for example, in a BTA, if there is a existing business that he is continuing, he would want to limit his risk. He wants to have a clean break at the end of the day. And also to answer this question directly, sellers are not comfortable at all with break fees in India, especially.
So I will make only one comment here. Too bad is bad. but too good is also too bad. So if somebody is giving the everything what you want, then you have to take a doubt, frankly.
And I would like to add that, COVID does not mean that the world has come to an end. It never was. So, you have legal principles whether that COVID was a frustration of a contract or not. In 99.99% of the cases, COVID will never lead to a frustration of a contract to end a M&A transaction. It can only delay a transaction if at all somebody has been prevented by COVID by not doing something. You have to demonstrate and prove. Force majeure does not mean if force majeure is in a clause, it applies automatically. You have to prove force majeure. So those kind of things, if your buyer or seller is wanting to add COVID-19, please add COVID-19, but also add a principle of contract that it will not lead to a frustration of contract. It will have to be demonstrated and proved. I don't think we have to worry about COVID-19 or other things leading to or not concluding a contract. I think we all very well know, even the central government, state government guidelines, they allow you to perform and conduct your business. It is these guidelines are enablers. They are not showstoppers, in my view.
Yes, thank you, Akil. I agree with you on this. I think, yes, Atul, please.
There is one question from Mohammed. Do you prefer arbitration or court for the dispute resolution? I will prefer mediation first and then arbitration. But if I have got a problem, then I will prefer court because I know that decision will not come. So I will prefer mediation first for the always faster results, and then arbitration. Court will be the last priority.
Unless it's specific relief and specific performance, injunctive relief and things like that. Yes. I think, I think I will end this discussion. Food for thought. I want to understand from you, Atul, and I want to understand from you, Akil, is in all the M&A deals that you all have done. I mean, there's a lot of effort. I mean, we've spoken for 1 hour now on the entire process, the pains that each stakeholder takes and all the consultants. But how many times have you opened, other than for operational reasons, how many times have you opened the agreement to see what the clauses are and to go back and try to, you know what I'm talking about, right? How many times has that happened?
I think I have done almost 18 to 19 deals in the last 37 years, but I think only 1 or 2 times I had to open the agreement because people matter most. The agreement remains in the shelf.
Correct.
So whatever good or bad business you have acquired 100%, perhaps, what's the need to go back to the agreement? If you have bought gold, you have bought gold. If you have bought crap, you have bought crap. But you have to go back to the documents the moment you create a joint venture. I think that's where the problems remain, because you have a partner who's making your life difficult, and your parent company business people ask you questions. What can we do in this meeting? Do we have a veto right, etc.? That is where you have to go back to the document.
Correct.
But otherwise,
that's exactly
whatever has been acquired has been acquired. Yeah.
Correct. Unless there's a problem that comes out, there's a dispute. I mean, you're hardly looking at we may make it as airtight as possible. But yes, the reason that we make these airtight agreements is for the cornerstone cases. If there is an issue, we need to be protected, each side. So I think we can conclude with, yes, everyone's working towards getting the deal to closure. Everyone has to work as a team to make sure that you bring it to closure. And more importantly, that both the parties become one team. You're working as one party post this. Yes, Atul. You're on mute.
No, I agree with you. Both the parties, once they started dealing, then they should work as a one team, and they should not bother about the exceptions. They should find a solution for the exceptions. Business is never a straight line. It is always surprises. Even deals also surprises. Sometimes the seller also doesn't know that this problem was there. It comes out in the due diligence that there's problem is there. So we have to handle that with the solution.
Agreed, Atul. Thank you so much. Thank you, Akil. Thank you, Atul, Rukmini. It has been delightful. It has been very insightful, enriching. I've learned so much from each one of you today, and I hope it's been useful to the audience too. Thank you, everyone.
Thank you. I'm sure it's been, Shweta, it's remarkably interesting and very useful, I'm sure. Huge thank you to KLO, to Mr. Juble, Dr. Prasad, to you, Shweta, to Rukmini, and to our audience, of course. And we hope to see you at another webinar shortly. Goodbye, everyone. I'm going to close the webinar now. Goodbye.